Mr. Chairman. Clearly, as my colleagues have noted, the Enforce Act is a deeply flawed piece of legislation. It would give any legislative majority a blank check to challenge in court by filing a lawsuit any decision of the executive branch that it disagrees with. Instead of considering legislation to create jobs, to fix our broken immigration system, repair our crumbling infrastructure, or raise the minimum wage, today the majority has brought to this floor a partisan measure to increase only one thing: congressional litigation. The bill raises serious constitutional questions and fails to put into place responsible safeguards to prevent abuse. This, I believe, Mr. Chairman, is a dangerous attack that threatens the careful balance of power developed by our founding fathers. And at a time when the American people have lost so much confidence in Congress, my Republican colleagues are offering yet another bill that will do nothing to improve the lives of Americans. Instead, this bill will only add to the American people's scorn and ridicule of Congress. Just what we need: more contention, more division here in Congress by encouraging congressional lawsuits. But in addition to its questionable purpose and substantive defects, the Enforce Act also fails to adequately protect taxpayer money, as it would open the floodgates to litigation for nearly any executive branch decision that a majority in either chamber disagrees with. And it would do so without a transparent accounting of taxpayer money spent. And that's why I'm offering this amendment today, which simply requires quarterly reporting of the costs associated with the litigation under this act. Specifically, it would require the Comptroller General of the United States to issue quarterly reports to the House and Senate Judiciary Committees on the costs of civil litigation actions brought pursuant to this act, including any attorney's fees. Since many of my colleagues have previously and routinely expressed significant concern about ensuring taxpayer dollars are used appropriately and carefully, one would expect the Enforce Act to have clear oversight and transparency provisions in place. However, it does not. And that's why I urge my colleagues to support my amendment, which would provide a transparent quarterly accounting of the costs of pursuing legal action under the Act. As many of my colleagues know, litigation can be extremely expensive. So let's ensure members of Congress and the public are aware of exactly how much taxpayer resources are being spent on pursuing legal action under this Act. And while disbursement reporting requirements already exist for federal expenditures, recent experience underscores their inadequacy to provide timely, transparent disclosure of precisely how much has been spent on litigation. For example, over the last few years, the House of Representatives, at the direction of the majority and over strong objections by Leader Pelosi and Whip Hoyer, hired outside counsel to defend the Defense of Marriage Act in court. What began as a contract for up to $500,000 in legal services to defend DOMA has grown through a series of contract extensions to be up to $3 million. And it's hard to determine at what point and at what cost the majority's pursuits will end. Today, nearly 9 months since the United States Supreme Court struck down Section 3 of DOMA as unconstitutional, we still don't have an adequate accounting of how much the House majority has spent on defending this discriminatory law, or whether it continues to spend taxpayer funding on this matter. And as minority members of the House Administration Committee reported during this legal challenge in 2002, and I quote, "No one seems to know where the funds are coming from. There's been no appropriation for this expense. There's been no mention of the funding source in the contract extensions. There's no record of payment being made in the statement of disbursements," end quote. Clearly, the existing reporting requirements are insufficient to inform members of Congress and the general public of its litigation disbursements. And while members may disagree on the merits of DOMA, as well as the legislation before us today, we should all recognize that neither side nor the public interest is served by obscuring the disclosure of litigation expenses. Therefore, I urge my colleagues to support my amendment, a simple reporting requirement that will safeguard and provide transparency to ensure that spending under this very misguided legislation is made clear. I thank and reserve the